Sorry about that. Thank you. Ms. Tabram, who do we expect next?
Mr. Sanders is just about through on his plea, and then he has Mr. Hansard also. So about 2 minutes, we'll be ready.
Okay.
And then Mr. Ashmore is going over paperwork with his two.
And we don't have any of Miss Beasley's clients, right?
Not yet, sir.
Okay.
Your Honor.
Yes.
Mr. Sanders is ready with Norman Hansard.
All right. It'll be just 1 minute.
Okay.
All right. This is cause number CR 2339, State versus Norman Wayne Hansard. Set for docket call. Mr. Sanders, go ahead.
Judge, we do not have a plea agreement on this case, so we would ask that for jury selection.
Okay. And can I hear the offer so that I know what Mr. Hansard's rejected?
It was 15 years TDC, Judge.
And Mr. Sanders, Mr. Hansard understands that a rejection of the state's offer today means that the court will not accept a plea agreement after today's date.
Yes, we understand.
So if he wants to take 15, the day we're picking the jury, the court's not going to accept it.
Yes, we understand that.
Okay. All right. Then the court will set Mr. Hansard for jury selection beginning on October 4th. And you will not, Mr. Sanders, you won't be required to be there, of course, until you receive the court's top 10 notice.
Okay, now we're ready on Deborah Lewis's plea.
Okay. All right, Ms. Lewis, if you'll raise your right hand, I'm going to place you under oath. Ms. Lewis, do you swear that the testimony you give to the court will be the truth, the whole truth, and nothing but the truth, so help you God? I can't hear you.
Yes, I do.
I can't hear you.
Yes, I do.
All right, you may need to step closer because I'm still having a, you're real faint. All right. So you said you do swear to tell the truth?
Yes.
All right, you may put your hand down. All right, Miss Lewis, are you a United States citizen?
Yes, I am.
Do you read, write, and speak English?
Yes.
Have you ever been diagnosed with any type of mental condition?
No.
In this case, you're represented by your attorney, Mr. Jeff Sanders. Are you pleased with his representation of you?
Yes.
You feel like you've had enough time to discuss the case with him and have all your questions answered?
Yes.
Is there anything about the paperwork that you've read and signed that you do not understand?
No, there's not.
Mr. Sanders, do you believe Ms. Lewis to be competent today?
Yes, Your Honor, she is.
And you've explained to her her legal and constitutional rights?
Yes, Your Honor.
I see here that the plea agreement is that she pleads guilty to second-degree felony possession of controlled substance, penalty group 1, 4 grams to 200 grams. State's recommendation is 6 years confinement, TDC, $2,500 fine, $180 restitution, plus reimbursement fees and court costs, with Ms. Lewis receiving 251 days credit towards her sentence for time served. Is that correct, Mr. Sanders?
Yes, Your Honor, that is correct.
And Ms. Lewis, that's your understanding of what you want me to approve today?
Yes, there it is.
All right, Ms. Lewis, the range of punishment for this kind of case is confinement in the Texas Department of Criminal Justice for not less than 2 years or more than 20 years, and a fine not to exceed $10,000. That's the legal range of punishment, and this plea agreement does fit within that range of punishment. Understanding the range of punishment in the plea agreement, how do you plead to possession of a controlled substance in penalty group 1 greater than or equal to 4 grams, but less than 200 grams?
Guilty.
Are you being guilty because you are guilty of committing that offense?
Yes, sir.
Has anyone threatened, forced, or pressured you to plead guilty today?
No.
All right, the court will accept the defendant's plea of guilt. Mr. Sanders, any objection to states 1?
No objection.
All right, states 1 is admitted and the court takes judicial notice of the defendant's judicial confession. Anything further from the state, from the defense?
No, Your Honor.
All right, I'm gonna take just a moment and review the evidence. All right, Ms. Lewis, based on my review of the evidence, I find that there is enough evidence to convict you. Court will follow the plea agreement in your case. Court does convict you of this offense. Court assesses your punishment at 6 years confinement in the Texas Department of Criminal Justice Institutional Division. Court orders you to pay a $2,500 fine, $180 restitution, $290 court costs, and $245 reimbursement fees. Court awards you 251 days credit towards your sentence for time spent in jail on this cause. Ms. Lewis, you're hereby remanded to the custody of the Van Zandt County Sheriff so he can carry out the terms and conditions of the sentence and have you go with the deputy to be fingerprinted. Once you're released from TDC, you're ordered to report to the Van Zandt County Courthouse so that you can make arrangements to discharge your fine, court costs, and other fees. Good luck to you.
Good, man.
Your Honor, we're ready on Mr. Chumley and I'm Casey Ashmore.
All right, Mr. Chumley, if you'll raise your right hand, sir. Sir, do you swear that the testimony you give to the court will be the truth, the whole truth, and nothing but the truth, so help you God? All right, you may put your hand down. Mr. Chumley, are you a United States citizen?
Yes, I am.
Do you read, write, and speak English?
I do.
Ever been diagnosed with any type of mental condition?
Yes, sir.
And are you undergoing treatment or on any type of medication for that?
No, I took myself off the medication last year. I could afford that bill.
Okay, and what is the mental disorder?
Bipolar and I have PTSD.
Okay, and do you feel like today, Mr. Chumley, that you have a rational understanding of the proceedings and what's going on in court today?
I do.
Okay, in this case, you're represented by your attorney, Mr. Ashmore. Are you pleased with his representation?
Yes, I am.
You feel like you've had enough time to discuss the case with him and have all your questions answered?
Yes, sir.
Is there anything about the paperwork that you've read and signed that you do not understand?
Yes, sir.
Mr. Ashmore, do you believe Mr. Chumley to be competent today?
I do, Your Honor.
And have you seen any signs that give you any concerns that he may be suffering from a mental illness that impairs his competency?
No, Your Honor.
And you've explained to Mr. Chumley his legal rights,
Yes, Judge.
and do you believe that he understands them?
Yes, Judge. We've actually asked for a little additional time in the past to be able to work through the difficulties getting together during the pandemic and going over this case.
All right, Mr. Chumley, you're charged with a second-degree felony offense of robbery that carries a range of punishment of not less than 2 years or more than 20 years confinement at TDC and a fine not to exceed $10,000. Do you understand that full range of punishment?
Yes, sir, I do.
I see the plea agreement is that you're going to plead guilty to that charge and the state's recommending 8 years confinement as your sentence with a $1,500 fine, court costs and reimbursement fees, with you receiving 221 days credit towards that sentence for time that you spent in jail. Is that your understanding, Mr. Chumley?
Yes, sir.
All right, understanding the plea agreement and the range of punishment, how do you plead to the charge?
Guilty.
And are you pleading guilty because you are guilty of committing that charge?
Yes, sir, I am.
Has anyone threatened, forced, or pressured you to plead guilty?
No, sir.
Court accepts the defendant's plea of guilt. Mr. Ashmore, any objection to states one?
No, Your Honor.
States one is admitted and the court does take judicial notice of the defendant's judicial confession. Anything further from the state?
Your Honor, I would just put on the record that the state has had no contact with this case since the time of offense. We have not
Thank you. Mr. Ashmore, I'm assuming that you and your client weren't able to hear Ms. Heisel, is that correct?
I think she said that she's been in contact with the victim and that the victim is okay with this. That's a guess, though.
It's close. It's about 50-50 on that. No, she said she's had no contact with the victim. And so there's no approval or disapproval of the plea. All right, anything further from the defense?
No, Your Honor.
All right, court's going to review the evidence. All right, the court's reviewed the evidence. I find enough evidence to convict Mr. Chumley of this offense. Court will follow the plea agreement in this case, convicts Mr. Chumley of robbery, assesses his punishment at 8 years confinement at TDC, orders him to pay a $1,500 fine, $290 court costs, and $20 reimbursement fees. Court orders he received 221 days credit towards his sentence for the time that he has spent in jail on this cause. Mr. Chumley, you hereby remanded to the custody of the Van Zandt County Sheriff so he can carry out the terms and conditions of the sentence. I'm gonna have you step over with the deputy to be fingerprinted. Good luck to you, sir.
Okay, now we're ready on Mr. Schroeder.
Sorry, I couldn't hear you. Say that again. Audio is not real good.
Mr. Schroeder, Your Honor.
Schroeder.
Yes, Judge.
All right, this is CR 2310, CR 213738, and CR 21242, State versus Dillon, Andrew Schroeder. I show that we're set for arraignment on CR 21242, bail jumping, and for docket call on the remaining cases. Have you had an opportunity to go over the indictment with Mr. Schroeder on the bail jumping charge, Mr. Ashmore?
I don't think I have that. And if I do, I looked at the wrong indictment, so no. He is aware of the charge. Is there any way I could ask the court to share the screen with us so we can read it?
There's going to be a fee.
Yeah, I'm sorry, Judge. I was looking at the other family violence indictment and discovery, and
This is outside my judicial responsibilities. I'll send you an invoice.
thank you, Judge.
Don't thank me yet. Can you see that?
Your name, is it spelled correctly? Okay. Spelled correctly here? Right here? And that the allegation, remember, it's just an allegation on April 13th. But you didn't appear. Okay. Judge, my client has identified his name spelled correctly both times in the indictment. He understands that the allegation is that on 4/13/21, he did not appear in court, that he's authorized me to enter a plea of not guilty and proceed with negotiations with the state. I think it'd be prudent and request the court waive formal reading of the indictment and allow us to carry on.
All right, the court will enter Mr. Schroeder's plea of not guilty into the record for the bail jumping charge. We'll set that for pretrial, as well as the other cases for docket call on October 26th or 14th, whichever one you prefer, Mr. Ashmore.
Just a moment, Judge. Let's go, Judge, let's go 14, even though that's a little bit of a quick turnaround. Oh, wait, no, I'm sorry, that'd be an afternoon docket. I have a conflict that day. I guess we better do, if I may request the 26th, Judge, I'm sorry.
All right, court sets all cases for October 26th.
Thank you, Judge. And Mr. Schroeder and I be excused, Judge.
Yes, sir.
Okay, Your Honor, we're ready to reset 3 on Ms. Beasley's cases.
Let's go ahead and bring all three up together.
All 3 come at one time.
Need Mr. Ellis, Mr. Ochiltree, and Mr. Walker.
Yes, sir.
All right, for the record, this is cause numbers CR 19-305, State versus Donald Ellis, CR 21-136, and CR 21-182, State versus Philip Ochiltree. CR 2200, CR 2232, State versus Austin Walker. Gentlemen, your attorney, Ms. Beasley, is unable to be in court today due to a family medical emergency. I didn't want to just leave you in your cell and send word to you. I wanted to bring you forward so that you were aware and to find out if there's any issue that needs to be brought to the court's attention today that can't wait until the reset date. And we would be looking at your next court date being October 26th. Let me start with you, Mr. Ellis. Is there any issue that the court needs to be aware of in Ms. Beasley's absence?
I would like to bring, when we come back on the 26th, I would like to bring up an issue because I've asked Ms. File a motion to withdraw because me and her are not agreeing on some things that done with the last indictment.
Okay.
You know,
So I'll make a note, that we'll deal with that on the 26th. I'm also going to make a note, Mr. Ellis, that you have failed to come to an understanding with any of your attorneys. Okay,
So,
I'm going to equally consider that, just so you're aware. All right, Mr. Ogletree, any issues that we need to take up today in Ms. Beasley's absence?
at this time, Your Honor, no.
Okay, all right, so you're going to be reset for pretrial. Mr. Ellis will be reset for docket call. Mr. Walker, any issues? No? Okay. All right, then Mr. Walker, you'll be reset for status. So nothing's changing in your cases. You're not losing anything or losing any right to bring up anything. So Mr. Ellis, get with Ms. Beasley and then I'll make a note and we'll discuss it on the 26th, okay? All right, thank you, gentlemen. Get your notice of settings and then you're good to go.
Okay, Your Honor, we're through with the criminal docket and then we're gonna bring up Mr. Platt, as defendant.
Okay, and go ahead and put Ms. Johnson, make her comfortable and move the microphone and camera, get her as close as possible. I don't know if it's being on that public or what, but the audio still kind of garbles for us over here. And the video focuses in and out, so it's not very good for us.
Okay,
Say again,
Which computer screen is this?
this one.
I'm gonna undo this and bring him to jail so that we can see.
Go ahead. You're probably going to be up here because the microphones are not picking up well. You have to just kind of stand in that blue circle or whatever, blue square, or whatever's up there. I can't remember. You may just have to be there so that my microphone picks you up. I'm going to step off the bench for just a second. I'll be right back.
Let me run back and grab my phone real quick.
okay, I'm gonna mute us again.
All right, court calls writ number WR 2148. State versus Jamie Johnson. Mr. Platten, this is your writ habeas corpus seeking bail reduction, correct?
Yes, Your Honor.
All right. And Ms. Johnson, can you see and hear Mr. Platten? Mr. Platten, will you just, and I don't think those microphones are on. Are they green?
I can hear both of y'all. Can you hear me?
I can hear you, but Mr. Platten hadn't said anything, I don't think. Let us turn these microphones on.
Phone's off. Yes, sir.
Ms. Heisel, you'll want to make sure that yours is on when you, okay. No, everything's digital. I've got a copy of your stuff that I'm using, but
Oh, I can hear him a little bit now.
I'll have to look that up. I don't know. You wanna step across and ask them?
Well, we got some downtime. Well, I'll wait.
We'll just try that one and see. All right, say something into it again, Mr. Platten.
Hello? Hello?
Ms. Johnson, can you hear Mr. Platten now?
Yes, sir, I can.
Okay.
Can you hear me?
Yes, and if at any time you can't hear, just raise your hand and we'll try to make an adjustment, okay?
Yes, sir.
Go ahead, Mr. Platten.
Your Honor, here's Ms. Johnson, but he's seeking bond reduction. As the court very well knows, she is on $1 million bond. And we would, begin by calling Claudia Wright.
Right.
Yes, Your Honor.
That's right. If you'll come forward to the witness stand, please.
I would also like to attend the court defense exhibits 1, 2, the hard show.
That's a no objection to the exhibits. We however, we are.
As you're aware, the rules of evidence in bail proceedings really don't
Can you hear me?
Apply. Your Honor. We have an article from Nathan Peck, and then it's called cause application.
So you said no objection to 2, but you're objecting to 1. All right, defendants exhibit 2, the affidavit of probable cause is admitted. All right, and then as to, what's the objection as to defendants 1?
As you can see, Your Honor, it's on bail reform, and also under 101B1E. So the rules that apply to this.
All right, defendants 1, the objection is sustained, and defendants 2 is admitted. So here's 1, if you want that back, or I can leave it on the record.
Ms. Wright, will you please state your name for the court?
My name's Claudia Wright.
Do you know Ms. Jamie Johnson?
Do serve in
How long now?
10 years.
And how do you know?
Uh, We are friends, and I also employ her.
What kind of work is she?
She had a severe and profound severed son, and she provides attendant and respite care. My son receives services through the state program class.
Can you tell us what respite care is?
So respite care is where I, as a parent, need a break So my son's received 750 hours of respite care a year through the class program. So, and those are done as I need them, whether it's just one 24-hour period or 12 hours or whatever. And then we receive 68 hours of attended care every week, and Jamie does 24 of those hours for me every week. And she's worked 3 for 4 years.
Does she have a place to live?
Yes,
Does she live?
she can come in with us.
And what residence would be, where's it located?
So I am in Rockwall at 1541 Coastal Drive in Rockwall.
This may sound a little intrusive, but do you have any from the street? If she were allowed to make bond or bonds lower amount she could afford, would you help her get to and from meetings or
Absolutely.
Just move it down to where she can.
no further questions? Sean?
Any questions, Ms. Heisel?
Briefly, Your Honor, no, approach.
You may.
Ms. Wright, do you, you said you employed, Ms. Johnson, is that correct? Do you pay her for her services?
Yes.
Okay. And how much does she make, what is your pay schedule and, what does she make in that schedule?
So when she does the attendant hours, she's paid $12.11. And when she does the respite hours, that pay is $8.30 an hour.
And then you said that the respite care can fluctuate from time to time, is that correct?
It's just $750, excuse me, 750 hours a year that can be done however I need them. My husband is a disabled veteran and with a debilitating injury. So he spends a lot of time in hospital. So there are times that when I need that, can't be in the VA, and so she will provide those hours as deemed, necessary. We have 750 a year, and then 24 hours a week from Section employees.
Okay. And do you pay her on a bi-weekly schedule, monthly
It is
schedule?
a bi-weekly, or excuse me, twice a month. So
No further questions. For Ms. Johnson.
Anything further, Mr. Platten?
Are you helping out with any of her bills, monitoring this?
currently, right now,
Yes.
yes, I'm taking care of her. What bill she has.
Are you familiar with finances?
And,
Do you know how much money she has in the bank or savings?
Well, not exactly, but for her last check, which was $678.
Do you know if she has much property that can be sold,
I don't know.
but you are aware of what she has in the bank?
No follow-up question.
All right, thank you, Ms. Wright. You may step down.
I call Betty Oxford.
Betty Oxford, Ms. Oxford, if you'll come forward, please. I'm not sure I placed Ms. Wright on her oath. Ms. Oxford, if you'll raise your right hand. Ma'am, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God? Please have a seat. Get as close to that microphone as you can comfortably, and just make sure you speak up loudly.
Mom, it's okay.
Are you okay? Would you please state your name? Introduce yourself to it.
Eddie,
Ms. Oxford, do you recognize this person here on the screen?
Yes, I did.
And who is it? Now, do you know where she resided before she was in jail?
well, she
She moved.
Has she lived around this area for some time?
No, she's lived, she lived in 10 years. She moved back to 8.
Ma'am, we can't hear you.
It's either 10 or 12 years she's lived in this area.
Does she have ties to this area? Here in East Texas?
Yes, she does.
Do you know if she has a passport?
I do not believe she does.
Do you know if she leaves the country much?
She does, no, she does not.
Does she have any family or friends outside the country?
And no, she does not.
Does she have any friends outside the state that she goes to?
No, she does not.
So it's pretty normal for her to stick around here in this area?
Yes, it is.
Now, you know that she's employed, right?
Yes,
And that's not really a full-time job. Correct.
that's correct.
Now, you are familiar with the finances, right?
With her finances? Not a whole lot.
Do you know if she has any significant property around to be sold?
She has a piece of land in Rose Point.
And do you know if money is owed on that land?
Yes, it is.
So she doesn't own that piece of land outright.
No, she does not.
So it's fair to say that the bank has a lien on that, never make payments for it.
Yes,
Do you know if she has much money in bank accounts? We heard here from her friend testifying, she has about $600.
Claudia has gone trying to Janie, so she would have more knowledge about what Janie has in bank than I do.
Okay. Do you know much about her personal effects? Do they have vehicles that could be sold?
Well, one is in the shop right now, and the insurance adjuster is supposed to let me know if they're gonna tow the car or not, so I don't know if they're gonna fix the car or tow the car.
And if she were to get that back, that's the vehicle that she would have for transportation, correct?
Yes, and that's good to attend the hearings and court and whatever else she can.
Do you know if she has any motorcycles, three-wheelers, or anything like that?
No, she does not.
Do you know if she has any expensive jewelry or watches?
No, she does not.
Any other items of property, guns, or anything that could be sold?
No, she does not.
Okay. Now, is it your understanding your daughter has been arrested for?
That is my understanding.
Now, she currently has a bond that is set at $1 million, right?
That's what I've been told, yes, sir.
And you've learned that it would cost $100,000 for her to be released through a bail bond. Is that correct?
Yes, sir, it is.
Can she afford to make that bond?
No, sir, she cannot.
So if it were 10%, which you've been informed would cost, it would cost $100,000 for her to release on $1 million bond, right?
Yes, sir, that's correct.
If it were reduced to $500,000, where she had to pay $50,000, could she afford that bond?
No, sir, she cannot.
Now, if it were reduced to $250,000, y'all have $25,000 that y'all could put toward a bond.
No, sir, she does not.
Okay. So it's pretty fair to say that she doesn't have a whole lot of money.
Yes, sir, that's correct.
Now, you understand that the judge has to listen to this information and set a bond that he determines is appropriate for this case, right?
I understand that, sir.
Now, can you tell me much about her family background? Does she have children?
Yes, sir, she has 2 sons.
And one child is in the Van Zandt County Jail, right?
Yes, sir.
And another child is living with those family members, correct? How old is the younger child?
17 years old.
And she had been taking care of his children all the while.
She-
Had she been one to follow directions? If she was told she had to be somewhere, serious things, would she abide by rules at times?
Yes, yes, she did.
If she were able to post a bond amount for the relevant to this case, do you think that she would appear in court?
Yes, sir, I think, yes, she would.
Do you think she'd appear at probation and take regular drug tests and stuff?
Yes, she would.
Would you help and assist in that if it was necessary?
Absolutely.
Ms. Heisel.
Where do you reside?
In North Texas.
In Midland, okay. And does she have other family in Midland?
She has an uncle, my brother and his wife, and she has my niece Alyssa and her husband and their children. And that's all in the middle.
Does Miss Johnson have any family in the East Texas area?
She has my sister, Karen, and brother-in-law. She has a male cousin and a female cousin.
And you don't have to tell me exactly, but just approximately where, what area?
In the Waxahachie area.
And so Ms. Oxford, with you being in Midland, if Ms. Johnson was released from jail and she were to reside in Rockwall, as has been the testimony, you wouldn't really have a whole lot of personal interaction in making sure she got to court, correct?
I would not personally know because I live in Midland, but I believe that Claudia would absolutely do that.
And you are working on finding out the status of the vehicles, is that correct?
Yes, ma'am, it is.
And if that vehicle is not able to be returned to Ms. Johnson, does she have any other mode of transportation in this area that you're aware of?
Yes, she does.
And what would that be?
It's my grandson's Mustang.
You're on the right path.
Any further questions for Ms. Oxford?
No, no.
Ma'am, you may step down. No further witnesses. Stay, do you want to put on any evidence?
Your Honor, at this time, state law states before the client has already been to the written evidence.
Okay.
State's Exhibit 1 is admitted. Anything further, Ms. Heisel?
Your Honor, states is right.
One argument, Mr. Platten?
Yes, Your Honor. You heard testimony from family members and from people that she lived with, probably right, that she has a place to live, that they would help her get to court, abide by court schedules, get to probation, things like that. You've also heard that she doesn't really have much of an ability to pay. It's very unfortunate that people are often incarcerated, stay incarcerated on an inability to pay. As you've also heard, she doesn't have a criminal history. Had she had any criminal history or any criminal history, I think that that would have been prevented to you. Thus, to our knowledge, she's been arrested. So we're here asking for to take that into consideration when you consider the factors of 1750. Ties to the community, yes, she's been here for a significant period of time. She resided in Rockwall, which we know is close. We all please take into consideration the safety of the community. This is not something that normally happens that often. Without charge. She still is presumed innocent, and she will have trial in this case. But when it comes to general safety of the victim, that's an unfortunate situation we're in right now because the victim's deceased. So I don't think that there's going to be a safety issue there if you wanted to put conditions where it's not in contact with certain individuals. Do that, or even GPS monitoring. There are things that the court has at its disposal that can be taken in addition to monitoring through the Commission Department for substance abuse. Back to money and ability to make bond. This bond at $1 million is going to keep her in jail. Not, this bond is set at a rate for her that is going to ensure her incarceration. And it's leaving this overall appearance of guilt. If she's not able to make a bond that she can reasonably afford and assist in counsel, it's just leaving this overall appearance that perhaps she is. Unfortunately, that sometimes happens. You know, she has a property interest in her liberty, in being able to be free in society while she's waiting for trial, which may take some. See how it does. But in this particular case, looking at the circumstances of defense, which you've got the indictment and probable cause update there, you're aware to see, you can see that she was not a direct actor that did something that immediately caused the death of this individual. She was present when this occurred, and we'll have to figure out exactly what happened, but she was not the direct cause of the death. We would ask that the court, in light of all these circumstances, consider a bond of $200,000.
Thank you, Mr. Platt. Seisel?
Yes, Your Honor. As has been presented to the court through State's Exhibit 1, you know, Ms. Johnson has already been indicted on charge of murder within those 90 days. I understand that Mr. Platt is not arguing under the 90-day rule, but we just wanted the court to take notice that that has been indicted, as such she is not entitled to the bond reduction. We did have significant concerns about her contacts with the community, which have somewhat been addressed in this hearing. However, given the nature of the charge, Judge, I'm hearing from the witnesses that there are lots of options for vehicles, but that there's not a solid guaranteed way of getting to court. We still have significant concerns about her appearance in court, and we believe that a bond of $500,000 would be enough to assure her appearance in court. We would further ask, Your Honor, for no contact bond conditions with both the co-defendant and with the victim's family in this case, in the event that a bond was made.
There was one other thing I noticed. There was one other thing that did not go into, Your Honor. That's the fact that she suffers from multiple sclerosis. Her mother is a resident. I don't think we want to reopen that, but she does have medical issues. She will get treated for it. I think.
Is the co-defendant related to Ms. Johnson?
Yes, it is her son.
And so you're saying no contact with the co-defendant? Not out of a protection for the co-defendant, but not to be having any discussions with the co-defendant, or is it out of a concern?
I think the state has both concerns, frankly. You have the probable cause affidavit in front of you, Your Honor. Obviously, this being his mother, we do believe that there is considerable influence that she can have over him. I don't believe at this point that there's any fear from the state of any physical danger to him from Ms. Johnson. However, just given the status of the situation, we believe it would be in the best interest of justice to err on the side of caution and request the contact for both the victim's family and the.
Another thought is that there is contact with the supervisor because it is her son.
Who would supervise that?
The state basically thinks that's no supervision at all due respect to Mr. Platt.
Okay, all right, anything further? All right, court's going to take this under advisement and I will issue a ruling tomorrow.
Thank you.
You're welcome. All right, Ms. Johnson, were you able to hear? Okay, good.
Yes, yes, sir.
We'll be adjourned in this case and I'll issue a written ruling and order tomorrow.
Okay. Yes, sir. Thank you. Ms. Johnson. Okay.
I think we are finished.
It's that prayer.
Hang on, Ms. Heisel, let me double check. Ms. Grisham says that we may be someone.
That prayer on the very first page.
Oh, he didn't show this morning. Talking about from the morning, he didn't show. So it's a condition of probation, so they can either follow revocation or. All right, Aaron, you want to try to test us? Let me stop our